Danielle Davis, partner in domestic relations here at Burnham Law, talking to you today about whether or not you're responsible for your spouse's student loan debt after divorce. This is a really interesting question, and I want to start by having you assess whether or not you have a marital agreement. That's going to be a prenup or a postnup. If one of those contracts exists in your case, you're going to want to look at it carefully and review the terms about debt, and then maybe talk to a lawyer about whether or not it applies to student loans and how that's going to apply in your given case. So that's the first part. The next is to decide, how do you assess whether that student loan is marital or separate? If it's separate, it's not subject to division during a divorce. If it's marital, it may be. That is determined most clearly by timeliness. Was the student loan taken out prior to the date of marriage? If so, it's going to be separate debt. It's not going to be your responsibility at the time of divorce. If the student loan was incurred after the date of marriage, the default assumption is going to be that it is a marital debt and subject to division during the division of the marital estate at the end of the divorce. The problem here is that Colorado is not an equal division state. We're an equity state. That means that our judges are vested with the right to decide what's fair and what's conscionable in the division of the marital estate. This gets more complicated when we're talking about student loans because who benefits from the education that was received? When was the education received? If we're talking about a longer-term marriage and the education happened at the very, very beginning and both parties have benefited from that increased income over the course of the marriage, in that case, I think it's more likely that the judge would decide that that debt benefited both of you and should be borne equally between you. However, if you have a case where someone got their education towards the end of the marriage, close to the time of divorce, and the real return on investment for that education hasn't come to fruition yet, if the future earning capacity is going to be coming after the divorce is over, the court is going to consider that in all fairness and does have the right under Colorado law to divide those student loans differently, disproportionately between you. It's possible, and there is case law in Colorado that says that it doesn't foreclose the right of a judge to assign some or all of the payment for educational debt to the person who took it out if fairness allows. If you have any other questions on this issue, please look at our website, burnhamlaw.com.
Thank you for watching. Make sure you subscribe, and for more information, go to burnhamlaw.com.